Um, First question, I have a few self-reflection questions for you. Do you currently have an estate plan? If your answer is no, you're in good company. Did you know that 62% of adults in the US don't have an estate plan right now? And when you're talking about families with young children, that number goes up even higher. So you're not alone. Why not? I've been collecting a lot of information in my community about what is the sort of resistance to this. Are you too busy, too young, too expensive? And the most common response I get is it seems overwhelming and I don't know where to do or where to start, which is why I want to do these webinars to get people to understand some basics, that it's not so intimidating, and to give you some common baseline knowledge that you feel a little bit more empowered to attack this challenging and different area. And what is it that you hope to learn today? Just to get a better baseline understanding. Have you done some steps online? Do you think it's sufficient? Is it outdated? We'll be able to go through all of those things. And I promise you, you'll take something away today. We also have a lot of fears when we talk about this. The number one fear is, I don't want to talk about the hard things. So we're talking about serious things, death and your incapacity. And it's much easier to procrastinate, to use the excuses that we're busy, we don't have time. And it becomes even easier when it's challenging. So my goal is to help relieve some of these fears. It will take too long. At the end, we'll step through what the process looks like and show you that it's mostly a couple of meetings and a lot of waiting time on your part until all the back end stuff is done. And the fear is that I'm not old enough or wealthy enough. And the reality is that people with more modest means are actually more directly impacted when families don't plan properly, because the added expense and the added emotional weight of having to deal with very complicated and stressful situations and maybe very much conflict is a really heavy weight and burden to them. So there's no sort of wealth measurement where someone qualifies for an estate plan. It's about how you want to protect your loved ones the best way possible. So you're right in the right place. If you have someone you care about, something you want to protect, you're right in the right place. If you did something that was a fill in the blank on the line will, and you're not sure if it will work when you need it, and you are in the right place if you're nervous about how much it costs, because I'll be pretty transparent about the costs at the end. The reality is estate planning is not about you. It's about the people you love the most, because they're the ones who are going to have to deal with the situations around your incapacity and or your death. And so your loved ones will know whether you lived up to the promise of, I took care of it. I hear a lot of times people's parents pass on and they thought their parents had taken care of it, and there's a lot of extra work involved in terms of finding documents, or for instance, a friend of mine recently had, their dad had a will, and it was very straightforward will, but there was no instructions about where to find the assets and where the accounts were, and even what sort of things he held. And there are over $1 billion in across the country in unclaimed property because people aren't able to trace down all those assets. So what will you learn today? We're going to do a little storytelling, and we're going to see the before of what if you had no estate plan or only a document here and there, and the after, where you have a very personalized estate plan that's tailored to you and your family situation. And we'll also cover at the very end about the details about how to start, how long it will take, and how much it will cost. I'd like to introduce me and my family, because part of my work is working with you and your family. So I think you should know something about me. The handsome guy on the left side of your screen is my son, Casey. He's my child from a previous relationship from my current husband over there on the far right with me on our wedding day about 20 years after we first started dating. And Casey just graduated a couple of years ago from Cal State LA in graphic design. So I've had an interesting lived life experience. I've been an attorney and a member of the Oregon State Bar for 15 years and had a variety of practice areas. That's me on the bottom there when I was working in a human rights institution based in Warsaw, Poland. That was actually from the cover photo of their annual report, where I was working as a trainer for law enforcement prosecutors and prosecuting hate crime. What I like to do in my off time, as you can see here, is I like to do a lot of biking and a lot of bike travel. So there are the three of us on a trip across Italy when we lived in Europe. And you can barely see my bike in that beautiful landscape of the East Cape of Baja from a few years ago. In addition to being a human rights lawyer, I've been a criminal defense attorney, done workplace investigations, and I've pivoted, like so many of us in the time of COVID, to come back to my community, to come back to my roots and focus here more in Oregon. I did a lot of international work and traveled all over the globe, but it was time to come home. And I wanted to find an area where I felt I could empower people into proactive planning instead of being in reactive crisis mode. My goal is to work with folks to proactively plan for better outcomes for themselves and their families. I'm also a member of Wealth Council, a dedicated estate planning network, as well as being designated a personal family lawyer with a full, robust training program on estate planning. So as we go through these next slides and get to meet our hypothetical family, I want you to think about who needs your protection. This is going to be a very specific family, but I want you to always be thinking in the back of the mind, how could this apply to me and my situation and my family dynamics and who are important to me? So we're going to take a journey with the Bliss family. Mark and Molly are the mother and father, with Alexander, Benjamin, and Olivia as the children. Alexander's 15, Benjamin is 10, and Olivia, or 12, and Olivia's 10. And they have pets, Rio and Whiskers. However, Molly, this is not Molly's first marriage. Molly was married to Xavier when they were very young, and it didn't work out. But they have their wonderful son, Alexander. Xavier, one of the things he did was to get a life insurance policy. And because he and Molly got divorced, he decided to rename the beneficiary because he didn't want Molly touching the money. So he named Alexander direct beneficiary. Now he thinks he's helping Alexander, but we're going to see how maybe that's not the best way to do it. Mark and Molly and their family are a sort of regular everyday family. They own their own home. They have life insurance. They have retirement accounts. Because it's Molly's second marriage, she has some funds she keeps separate. They have some separate accounts and separate savings they brought to the marriage. Molly also has an inheritance she got from her parents that she's kept separate and stowed away because they don't need to touch it right now. Molly has also gained a vacation home in Lake Tahoe, California. This was something she and Xavier shared, and she earned sole title to it during the divorce. So nothing excessive in terms of assets or anything like that. It's an everyday sort of family. But there's going to be sad days ahead, unfortunately. And I hope you'll realize that in these types of presentations, I don't take death too seriously because it all comes upon us at some point. And it's important that we're able to go through some of these scenarios and see what the worst case scenarios are. So sad day number 1 is Xavier turns 40 and he decides to go skydiving. Unfortunately, the equipment failed and malfunctioned, but remember, he had life insurance. $1 million with Alexander as the beneficiary. So now Alexander's quite excited. He's considering himself a teenage millionaire, thinking of all the lovely fancy things he's going to buy. Meanwhile, Molly is very concerned about Alexander coming into this much money. He's only 15 at this stage, and realizes there's going to have to be someone who controls the money. So because all we have is a life insurance policy, we're going to go to probate court, and it's in public and it's a stranger who's going to make these decisions on their timetable according to who's best placed to control the money for Alexander for his benefit until he turns 18, at which time he's still a teenager and will get the full $1 million. So all those plans he's dreaming up at 15, he's got 3 years to figure out how to blow through all that money when he turns 18. The probate court can be very intrusive. They'll look at credit reports, background checks for Molly, and Molly's thinking, I'm his mom. It should be no problem. But the guy in the red shirt shows up, and that is Zachary. And Zachary is Xavier's brother. And he knows that Xavier didn't want Molly to have any control over this money. So he has a right to go before the probate court and ask to be appointed a financial guardian. So who is the judge going to choose? Molly or Zachary? The answer is, and it's a lawyer's favorite answer, we don't know. Because of 2 things. It's very fact specific, and it depends. And it depends on what all those facts are and who is going to look best, oftentimes on paper, to a judge about who that financial conservator is going to be. So, can we do something better? Yes, we can. Let's have some ideas. One idea is that we name Zachary the beneficiary instead. But that's not necessarily a good idea. Zachary, Xavier's brother, is not required to use the money for Alexander because it's Zachary's money. Now, Xavier may have had a conversation with Zachary and told him what he intended to do and made him promise to do all these things, but that might all go by the wayside when there's $1 million check, according to Zachary, made out to Zachary at the end of the day. He may decide to use some of that money. The other thing is that because it becomes Zachary's, it is exposed. If he gets into lawsuits, has significant credit debt, or during a potential divorce with an ex-spouse, that money could be go to any of those issues. It's not protected, and it's not guaranteed for Alexander. The next option is Xavier signs a will, and it says, I leave everything to Alexander, and if he's under 21, I put Zachary in charge. Sounds like a much better system, right? However, what Xavier doesn't realize is that your will does not control all of your assets. Joint ownership and beneficiary designations override your will. So it's as if they don't even exist within your will, right? So think of it this way, is that there's 3 buckets. One is jointly owned assets, and typically we think of that as real estate that's owned as joint tenants. particularly joint tenants with right of survivorship. So when one person dies, the survivor automatically inherits their right to the property and becomes entirely that sole survivor's property. The other aspect is beneficiary designations. So life insurance policies, retirement accounts, we designate who the beneficiary is upon our death. And so those things flow outside of your probate estate. So anything that's left is inside your probate estate. So any other accounts, any property you've owned individually, and it will pass according to your will if you have one, or state law if you don't. Assets are not immediately available, and loved ones must go to probate court to get access to them. So what's interesting about this is that even though it says everything goes to Zachary, by definition, the bucket of beneficiary designations of life insurance isn't even covered by that will. So while he thought he was doing the right thing, he wasn't. A will does not avoid probate court. In fact, it requires probate. It's the only way to dispose of the assets that are probatable. So idea number 3. Xavier establishes what we call a revocable living trust. And it says, if I leave everything to Alexander if he's under 21, and I put Zachary in charge. Now, this looks like the exact same provision as the will. So how does it work differently with the trust? The trust is essentially a will substitute, except it doesn't go through probate court. So basically, these are how the 3 buckets work within a trust. Your share of jointly owned assets can be put into the trust. So your half of the house can be then put into into the trust. Your beneficiary designations are made out not to an individual, but to your trust. And then all the other trust assets that you have are titled in that way, and they're immediately available for your loved ones with no court required. So it's like a red wagon. There's no probate court for the assets you put into the trust. They're like toys in the red wagon. So, and this is the important part. If you don't put anything, if you don't fund your trust, your assets still go to probate. So you can go to an attorney. This happens more often than you think. Have them draft up a trust, but unless you title your assets themselves to belong to the trust, your trust isn't worth the paper that it's written on, and you'll still have to go through probate court, which is what you were trying to avoid in the first place. And anytime you go into court, you invite conflict. Anytime your wishes aren't clear and desires aren't clear, you invite conflict from people who may have different ideas and visions, oftentimes well-intentioned ones, but think they may know better than others, as we saw with Zachary and Molly. So you must fund your trust, and then all of your assets are all those trust assets avoid probate court, and you have much quicker access to support your loved ones in that process, because all it requires is going into an attorney's office and doing paperwork in order to transfer the titles of the property to the new trustee. So basically a trust, another way to look at a trust is an agreement to hold property for the benefit of a third party. So the agreement is by a grantor, which is you, and the trustee holds that property, and that can also be you, and it's for the benefit of someone else. And that, while you're alive, is also you. So it's when you pass or you're incapacitated where you pass on some of that trustee responsibility to a spouse or an heir, a child, a niece, a nephew, in order to maintain your affairs if you're incapacitated, or to receive the benefit of those assets upon your death. So lesson number 1, a review of all your assets must be part of your estate planning conversation. One document alone is not enough to protect you. And that's why I find this visual of gears so important, because these are moving pieces. They're not just puzzle pieces that sit and lay flat. They're constantly moving. So if you adjust one thing without, tightening a socket down on another piece, it may not run together as you want it to work when you need it. So it's really important to take a look of everything as part of a comprehensive review. Sad day number 2 is your ski weekend. It started out fun. The family went skiing, and then they dropped the kids off at ski school, but a fog descended on the mountain. They also brought their friend Dina with them, and she stayed behind in the lodge catching up on some reading. She's someone the kids love and know, and they brought her along to help out a little bit with the kids because the parents are such big skiers. And they went out to Sun Valley in Idaho. But unfortunately, things went bad. They collided with each other. It's a yard sale, and they're just trapped in the snow. When the first responders come, they take a look. They are able to find Mark's cell phone, which shows an image of a loving family. So they know they have kids, and they're likely back at the ski lodge. But where are they? So Dina tries to go and collect the kids and telephones Mindy, who is Molly's sister, who lives in Texas, to come. There's been an accident. Both Mark and Mindy or Mark and Molly are very hurt, and the kids are here. We don't know how long it's going to take Mindy to get there. She may have other responsibilities. She's trying her best. How soon can she get a flight that's affordable for her? And you'll be surprised to learn that Dina can't take those kids. Those kids were legally signed off by those parents into that ski school, who are technically legal caretakers for them in the parents' absence. They signed all those waivers and everything. And so they're not able to just release those kids to anyone who isn't a blood relative. So even though Dina is very comfortable with those kids and would be a great place to stay temporarily while Mindy comes, we're not sure if they're going to be able to do that. They may, and especially because they're in Idaho, they may have to go into foster care while they wait for Mindy to arrive. And those kids would be further traumatized from a situation where they're already concerned about their parents. And the pets are back home. This is a good call out for all our pet owners. What happens when no one thought to contact the pet sitter? And perhaps no one even knows who the pet sitter really is. And so the pets may get taken to the pound because the neighbor's calling in that these whining and barking pets next door are there's something wrong. There's no one there to take care of them. So can we do better? Absolutely. One of the things we do is not only think about long-term guardianship, but short-term guardianship. So you have an emergency plan so the children are always exactly with who you want, no matter what. And this doesn't have to be a long-term situation. It can be a matter of hours or a matter of a day or two. And it's usually thinking about people who are local, especially if your family is out of town or lives far away. this is a really important piece to the puzzle that so many people forget, is that figuring out what to do in a short-term emergency. And the key piece to all of this, and so much of estate planning, is not the documents themselves. Yes, they are important, but it's all of the work around it. It's all of the communication. It's making sure people know what to do in an emergency, that they have copies of documents on hand that they can use and show to appropriate officials. So it's as much about understanding the process as it is about having the right documents. And this way the pets can stay safe as well, because everyone's been aware of the situations in the emergency plan. Sad day number 3, Molly's injuries linger. So now Molly's in the hospital. Mark is doing better, but he's still very stressed, and he's making medical decisions now. Meanwhile, Mindy has landed at the local airport. So Mindy calls the doctor and gets the red stop sign of HIPAA. I think everyone knows what HIPAA stands for. If you've been to the doctor in the last 10 years, you've signed some sort of HIPAA authorization. But there's no HIPAA authorization from Molly authorizing any doctor to speak to Mindy. So he can't tell her anything. Meanwhile, Mark is trying to pay some of these bills for Molly's medical expenses, and she has this separate inheritance account that she's kept her own, and he thinks because he's her husband, he should be able to go down to the bank and get in there. It doesn't work like that, not even when you're married. Marriage provides a lot of protections, but not all of them. So he can't get into the bank account to pay those bills because Molly could get better very soon. Meanwhile, Mark and Mindy, Molly's sister, are having terrible disagreements about Molly's healthcare decisions. Molly is really insistent, true faith believer, and believes in miracles and wants to do very radical, invasive procedures. Mark wants to be very holistic and a little bit more hands-off and not torture Molly if she's not going to survive. So again, Mark thinks, well, I'm the husband, so I should be able to get to decide. But the law says any interested party can has a right to help with healthcare decisions. And as her sister, Molly certainly is an interested party. And now we also need to get somebody to be able to access Molly's financial accounts to be able to handle her money. Maybe she also has bills to pay and things are stacking up that comes out of her personal accounts, and Mark doesn't have the resources to pay those. So who's the probate judge going to do? Again, we don't know. The answer is we don't know. And it's up to a stranger in a very public setting to make those decisions. So can we do better? Of course we can. So in this case, Molly has, can herself, not the probate judge, help decide who is going to make her medical decisions through a medical power of attorney. And in this case, she has chosen Mark. And Molly's also signed proper HIPAA releases ahead of time so that her sister can get the information from the doctor so she knows what's going on. Molly's got that, and she gave copies to everyone. Molly can also name the a financial power of attorney, also known as a durable power of attorney, so that Mark can get into her finances and take care of that for her while she is incapacitated. Lesson number 2. I think this is an important one. The only other person who can make your decision is a probate judge, a complete stranger who's following the best rules we have as a society, but we don't have to let that happen. And, people can think that, well, this is hard and why do we have to go through all this? But then think of it on the flip side. We're talking about taking away or having someone responsible with very serious healthcare rights, with your property, potentially with your children. So we as a society don't take those decisions very lightly, nor should we. And we do our best with objective rules to do that, but it may not always be take into consideration all of the factors you would in deciding who to make those decisions for you and who to take care of your assets and your kids. Sad day number 4 is when Molly passes away. So in this case, when do we pull life support? All we want to know is what Molly wanted. We don't ever want to have to put that decision onto someone else as to how and when someone should pull the plug. And so what you can do in your advanced health care directives and living wills is to say, after 30 days, if I'm still on life support, it doesn't mean that I'm really coming back. I have a friend who's put in her advanced health care directive because she's a healthcare, alternative healthcare worker. So for her, being in tune with the other side is very important. And so she's requested that a shaman sign off on it before her husband's allowed to pull the plug. So you can do what feels comfortable to you. And the minute she put that in there, she felt a sigh of relief and peace of mind. And that's what this is all about, is doing what works for you and gives you peace of mind. So now we're going into Alexander and his guardianship. Now, Mark, who's the stepfather, right, Molly's husband, wants to take on Alexander full-time. He's been living with them full-time already. He's got his 2 half-siblings. He thinks it's a very good place to live. Now, in comes Xavier's mother, Alexandra, for whom Alexander is named. So they have a very close relationship and share a special bond, having lost Xavier, who respectively was their father and son. And so she's very concerned that she doesn't know Mark very well and worried that she would get cut out of Alexander's life. So again, we're faced with going before the probate court, and who will the judge choose? We don't know. It turns on the specific facts and the circumstances, and it depends on what each person brings. But obviously, each person brings a valid argument and good positions on this issue. Another piece, paradise turns into a headache. So that piece of property down in California at Lake Tahoe, that was their beautiful retreat. They go a couple times a year. It's going to be, now Mark is going to be subject to what we call double probate. So because that is in another jurisdiction, and there's no wills, there's no trust, there's no anything in place, that has to, and it belongs solely to Molly. She never did any sort of joint documents. She's always kept that as her personal property. That's going to go up to probate. Mark will have to hire an attorney down there, go through probate cost and all of that in that venue as well. So can we do better? Yes, we can. So Molly's final wish is known. She creates a healthcare directive that gives some pretty specific instructions to her to the medical power of attorney to say, this is when I think you should pull the plug. So again, the medical power of attorney will still make that decision, but now they have guidance. They don't have to know what Molly would have wanted or known what was best. Molly told them in her documents. Molly can choose the guardian and decide who will be Alexander's guardian. In this case, she's chosen Mark for continuity and the sibling. But she also went above and beyond the legal documents, and you can set down guidance for your guardians. And one thing she told Mark was that she would like Alexander to maintain his close relationship with his grandma. And so now Alexandra doesn't have to raise another teenage son. I did it once. That was good enough for me. Wouldn't want to do it again. And she can be grandma. And so, and that way there's less conflict, and it invites less conflict. Mark is very happy to honor Molly's wishes as a way to honor her. And now if she put her bill to trust, just like we talked about, if Xavier had done a trust, well, now the Bliss family could have done a trust, and Molly could have put title to that into the trust. They could have also kept separate trusts that still would have had descriptions to be able to flow down to either the spouse or the kids, or to split it up into different sub-trusts upon her death. There's a lot of creativity you can do there that we don't have time to get in here now. But the point would be that even though it occurs in another state and it's owned in another state, it wouldn't have to go through probate. This could all be done through lawyers' offices and just simply transferring titles. Paperwork. So again, the key piece is you must fund your trust. All trust assets avoid probate and are immediately available to your loved ones. Lesson number 3, if you want to control what happens to yourself, should you become incapacitated, your loved ones and your assets, you must act before something bad happens. I did a lot of work in a previous career in risk management, and one thing we always talked about is like, no matter how remote that risk is, when the impact is severe, you've really got to create that contingency plan. And that's what I think of estate planning. It's really just another form of risk management. Probably the risks of a skydiving accident or skiing accident causing some of these scenarios are pretty low. But we've seen the impacts are pretty significant on the people involved if we don't plan ahead. And you can only plan ahead. You can't cure it afterwards. It's a different process, and it's a lot more work and tends to invite more conflict. So day number 5, Mark ages. And Mark, he should have learned his lesson by now. He still never got around to doing all the important planning that he should have. And so who comes first? The IRS always gets their cut first. How much did the IRS receive from Prince's estate? If you recall, he died a few years back, and there was quite a hubbub that he had no will, he had no estate planning. Prince probably thought he was going to never die. He was Prince. But what do you think they got? The IRS got? Is it 30%, half of it, 100 million? Well, the IRS took about 120 million. Now, most of us are pretty free and clear of the IRS taxes. Right now, they're at about 12 million exemption. So until you have $12 million worth of assets, and if you're a married couple, that would add up to $24 million. You won't have to worry about this 40% tax. However, Oregon is $1 million. And even when looking at Xavier's $1 million life insurance policy, if he adds up his other assets, if he had other retirement accounts, houses, things like that, he could quickly come over that $1 million threshold and be subject to an estate tax anywhere from 9% to 16% is a graduated tax according to where you fall in that. Some people are okay with that. They're happy to pay taxes. That's fine. And some people want to preserve as much for their children and heirs. And for some people, it's about ways to do charitable giving so as to ensure their money gets spent in the way that they believe is good for society. Keep in mind, distributions can also be outright in these situations under a will. So, and in a trust as well too. You can set things up so that things are better. Like we said, that's our motto. Let's do better for the Bliss family. So there are a lot of strategies where estate taxes and can be minimized or eliminated with planning ahead of time. And you can provide children with some lifetime asset protection. There are aspects of trust where children, you can create them for your children, whether they are teenagers or adults, and especially if they're young adults, to have some sort of co-trustees or independent trustees who help mentor your children on proper financial plannings and resources and things like that. These can also make sure that they're distributed or according to ages, so that they get more mature or in different different spots in their life cycle of where they might need a down payment for a house. So ages or for reasons like to start a business or to purchase a house. So these are things to sort of help your own children be better money managers in their own lifetime. And it can also, there are ways to also protect that money for your children from their lawsuits, from their creditors, from any potential divorces from spouses taking a significant chunk of that inheritance from them. And your pets can go to a guardian. Lesson number 4 is that the IRS and the state of Oregon always come first. Most importantly, your loved ones just need time to adjust and build in for this. And so I just want to switch gears for a minute and remember that we're not just talking about money. We spent a lot of time talking about that, but what's it really like after your loved ones are gone? They will miss you. And what do they care about the most? It's usually not your money. It's your intangibles. It's your legacy. It's your insights, your stories, the memories of you that are captured in little pieces of pottery around the house. My husband has these 2 very odd mugs. They're not matching. That is grandma and grandmother and grandfather used to drink out of every morning. And he loves when we drink coffee out of that because it reminds him of them. So it's this part that is also just as important of your legacy, to share those values, those stories, those experiences. And so that's why you're here, not necessarily to leave all that money, but to leave a part of who you are behind for those that you love. And there are great ways to do that. So in a traditional experience, you work with a lawyer and it's about hourly fees, knee-jerk responses to problems, and very focused on document transactions. The way I work is much different. I work on a flat fee so that you're never afraid to call me, whether you have a question, now or in 6 months from now. We plan ahead to avoid problems. That's the big piece, is let's not react and let's talk about building a relationship. This is relationship-based law is what I try to practice. So it's not just about passing on your assets, but we make time to talk about how to pass on your legacy and make room for legacy interviews and recordings and different experiences like that in order to pass on everything, the tangible and intangible you have. Our promise is that we leave no stone unturned and give you peace of mind, and your loved ones and assets are kept out of court and conflict. So we basically have a 3-step process, which starts out with the family wealth planning session. And for people who attend this sort of training or webinar, I waive that fee. It's usually a $750 fee because you're going to do a little bit of homework beforehand. We don't want to spend time with each other while I gather information about your general assets, your family, things like that, some of your values. So if we can do that ahead of time by filling up just a little bit of paperwork, then we can dive right in, and I can explain to you what's going to happen right now under your current plan or your lack thereof, and what are important pieces for you to choose in designing and moving forward. And if it's a good fit, we decide to work together. We form an engagement letter, and then you choose your plan that you want. I'm not in charge of that choice. I'll show you the different options, and there's different budget ranges and what's most important for you in your planning, and that's your choice. And then we'll move into the design session. And from there, we'll have a little bit of back and forth where I'll ask you to make some hard decisions, but you can revisit them because we're going to have a chance to compile that information, present a summary to you, and give it back to you for further review and discussion. And once you sign off on that, I send it to my paralegal team to draft it, and then I'll review that with a keen lawyerly eye. That's my specialty. And from there, we'll set up a signing ceremony where you get to sign all the documents, and it feels very empowering. We'll take those back because we'll put them together in a very nice binder, very comprehensive planning, because that way you can find it when you need it. And in addition to that, there's a lot of wraparound documents around communications, about what's in the plans, about how to communicate with your trustees or your personal representatives, all the people who are involved in it. And it's also going to have a good inventory of all your assets, so people will know where to find things. And you just keep that updated. And we have processes to help you with that ongoing. And with that, it generally takes about 6 to 8 weeks. But, it's 3 meetings, and most of that time is offline with me preparing documents, with you making decisions in the front end. So here's the 3 plans that I work with. First one is a will plan. So it's those who just want to do a will, some healthcare directives and powers of attorney. Includes a guardianship plan also for short-term and long-term guardians for children. So really build in what we call our kids protection plan. And it's for those people who don't have really any assets that go through probate, but want to guarantee their minor children are taken care of, health care is insured, and all those important things. The trust plan builds upon that. It has all the benefits of the will plan, plus peace of mind, knowing that you have total assurance and peace of mind, knowing your assets and legacy will be passed to your heirs in the most ease and convenience possible, privacy of an attorney's office without court involvement. We do include a will. We call it a pour-over will, and it's just sort of another safety net. So if we miss any assets, something doesn't get put into the trust, it's a way to sort of capture them and tell them, okay, put them in our trust over here. So ideally, there's really no need for the will, but it is a good backup plan. And then finally, the legacy plan includes everything mentioned before, but in the trust plan, we have an option for do-it-yourself. So you can transfer your assets into the trust. We help with one of the biggest ones, the house or your real property. But under the legacy plan, this is for people who have more money than time and would rather invest it in someone taking it all off their plate and say, you do all the transfers. I've got quite a few pieces of the puzzle, and and it would feel better for me if someone else did it. So those are the 3 tiers of planning that we have. And legacy plan will be single for $8,000 or a couple for $9,000. The trust plan comes in at $5,000 or $5,500, and the will plan at $3,000 or $3,500. For anyone without children and without need of a kids protection plan, I'll always knock off $500 for that. So what you create is a personalized plan for your loved ones, capturing your family wealth, both tangible and intangible, and going home with peace of mind. So as I mentioned, just want to throw it in here. There's my link for my free family wealth planning session. So that's a $750 value to come get organized with me, get understanding your assets and what's going to happen in your particular situation. Because I can't answer that here. I can give you some general guidance on the Bliss family, but this is an area where I can give you a little bit more specific feedback on that. And if you choose to work with me, I'll also give you an additional $250 of credit towards planning services. So I'll keep this offer up for the week. I'll also be sending follow-up email. I love to share the replay with folks, and you can feel free to share it with other folks as well, the replay, if you find something in here that you think they need to hear. I'm just looking now. We've got a few minutes left. So let me see if there are some questions. Any questions in the chat? Oops, I didn't put, okay, there's my coupon. Yes, so you can schedule your free session there. Again, I'll be including links for scheduling in the any follow-up emails for this, where I share the replay. Okay, it looks like I got a question in here. I don't have a large estate. Do I still need a trust? Again, that's a personal choice. There's certainly no threshold for creating a trust financially. There will be some attorneys or particularly financial advisors who will advise, well, only if you get into this point do you really need a trust. Well, certainly if you have enough different kinds of assets that start to add up and you have minor children, it's about, do you want the ease and convenience of the world of a trust? We used to think this was just for wealthy people and they took advantage of it, but more and more we're starting to realize this actually benefits just about anybody who owns their own home, has some retirement and life insurance accounts, sort of those basic pieces in their lives. So there's no real dollar value, but if it's more about what is the important in the process itself. And we can go over the benefits of a trust in a little more detail. Okay, oh, here's a good one. If I do an estate plan here and I move, is it still applicable? It's a very good question. So what happens is that generally all this stuff is transferable, right? It's full faith and credit across the US. So these things are going to be legally enforceable. What happens is when you move to another jurisdiction, there may be slight differences in inheritance laws. Oregon is actually one of the few states that has a pretty low threshold for an estate tax. So if you move to another jurisdiction, you'd actually be quite, you probably wouldn't have an estate tax. So it's always good to get it renewed or reviewed by an attorney in your new jurisdiction. But if something happened before you could do that, it would still work. It would still be effective, certainly. And it's better to do something than to do nothing, I think. Yeah, so we're just about to hit the 1 hour mark. So thank you all for coming. Again, here's phone numbers, email addresses, and the website. I believe the links are still good. So please feel free to reach out to me with any questions. Also, I'm happy to get on a 15-minute call is another way. We could just have a little bit more chat about anything that's come up here for you. And I thank you for your time, your attention, and your attendance. And I hope it was useful for you. Thank you.